Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on the concept that can the assessing officer do the addition of the same amount in the same assessment year on the protective basis if the assessing officer has added the same amount as substantive. And the second issue was that if the assessee issues the share at a premium based on the discounted cash flow method value which is calculated as per rule 11 UA of the income tax rules 1962, so whether the assessing officer can reject that value just on the basis that the values taken by the assessee are fake or bogus. These both the issues have been decided by Honorable Delhi ITAT F bench in the case of Sunstone Learning Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 138 ITR Tribunal, short notes 21, and the date of the judgment is 24th June 2026. In the present case, the assessment year involved is assessment year 14-15. The assessee has issued 3230 shares of the par value of rupees 1 each at a premium of rupees 1299 per share, totaling an amount of rupees 4.19 crore as the share capital from two entities. The case of the assessee was chosen for scrutiny, and when the scrutiny proceedings were going on, the assessee was called upon to justify the amount of the premium. The assessee produced the valuation report obtained by the assessee on the basis of discounted cash flow method as per rule 11 UA of the income tax rules 1962. When the assessing officer pursued the valuation report, he made an opinion that the values taken for calculating the value of the share are fake and bogus, and hence the valuation report of the assessee cannot be rejected, and the assessing officer suo motu calculated the value of the share as rupees 16.4 per share as compared to the assessee value 1299 per share, and made the addition of rupees 4.14 crore under section 56 subsection 2 clause 7 clause B. When the assessing officer made this addition, the assessing officer made this addition as substantive addition, and at the same time the assessing officer made the addition on protective basis of the same amount under section 68. The assessee challenged this order before the CIT appeal on the ground that at the same time the same amount cannot be added as substantive and protective, and the assessee has a right to choose the method of valuation, but the CIT appeal rejected the appeal of the assessee summarily. When the matter was before the tribunal was of the very foremost view that the assessing officer has grossly erred in rejecting the valuation report which has been prepared by the assessee based on the discounted cash flow method as per rule 11 UA. It was the viewpoint of the tribunal that the assessing officer cannot change the method of valuation adopted by the assessee. If the assessing officer was having any issue with the valuation report, then he should have pointed out the specific reason for doubting that valuation report. So the tribunal deleted the addition made under section 56 subsection 2 clause 7b, and for the protective assessment, the tribunal said that the protective assessment can be done by the assessing officer only when the learned AO is in doubt as to in whose hands a particular income was to be taxed and not otherwise. So the tribunal deleted the addition made under section 68 on the protective basis also. The tribunal further said that the addition of the same amount cannot be done both under the substantive head and under the protective head for the same amount for the same assessment year. Friends, this case is very important because when the section 56 subsection 2 clause 7b was on statute, because now it has been deleted, so at that time the assessing officers was not accepting the DCF method adopted by the assessee. So although there are a number of cases on the same line, but this case is also supports and in line of those cases. At the end of this video, once again I am repeating the name of the case. The name of the case is Sunstone Learning Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 138 ITR Tribunal Short Notes 21, and the date of the judgment is 24th June 2026. Thank you, friends.